Welcome to Law Talk with your host, Carl Fredericks. Law Talk is a weekly program featuring a panel of attorneys to probe, discuss, and explore the various areas of the law that may affect you. Our panel of attorneys are here as a public service so you may better understand the laws that protect us and that we live by. Questions or comments for Law Talk may be directed to info@lawtalk.tv.
Good evening and welcome to Law Talk. Tonight we're going to be talking about motor vehicle law. Again, your rights and responsibilities when you're in an accident. With me tonight to join me in that conversation are two attorneys who have represented victims of motor vehicle accidents for the better part of their careers. First, Rob Rubenstein of the Rubenstein Law Firm in Trenton, and Steve Schatz of the Philadelphia law firm of Master, Weinstein, and Schatz. And good evening, gentlemen, to you.
Good evening.
Good evening, Carl.
Gentlemen, as we know, there's millions of motorists each year that are involved in motor vehicle accidents. And most of them do have insurance, yet they seem to have roadblocks presented to them when they attempt to exercise the rights under their insurance policies. Rob, I want to begin by asking you, when someone renews their automobile insurance, what's the single most important coverage selection that they can make?
Well, Carl, to me, the most important coverage is to choose what's called the no limitation on lawsuit, or in other words, what many people commonly refer to as the no threshold. And that has to do with the rights that a party has to bring a claim for their pain and suffering if they've been injured due to the fault of another driver.
Now, when you say no threshold, the converse of that would be some sort of threshold?
Correct. And in New Jersey, if you do not make a selection, you're automatically given what we call threshold. Many refer to it as the verbal threshold. The real word is limitation on lawsuit, and it's just that. It limits your rights to bring a claim against an at-fault driver unless your injury meets a certain category of injury. In New Jersey, there's 6 categories.
And what are those 6 categories in New Jersey?
Death, dismemberment, significant scarring or disfigurement, loss of a fetus, displaced fracture, meaning a fracture where the bones are separated, or a permanent injury or loss of a body part or function, which is sort of a catch-all that could include a neck injury or a back injury or a joint injury of some sort, but it requires a certification or affidavit from a treating doctor that the injury is permanent and will never heal to function back as it was before the accident. And the purpose behind that is to essentially, in New Jersey, the insurance companies have tried to eliminate what we colloquially refer to as a soft tissue injury.
Okay, now Steve, over in Pennsylvania, I know you practice on both sides of the bridge, but on the Pennsylvania side of the bridge, are you up against this verbal threshold?
Yes, it's called full tort or limited tort, and the person has to make an affirmative election when they go in for their insurance to meet their insurance agent. If you have to sign a waiver of your rights in regard to electing limited or full tort. You sign off whether you want full tort or limited tort. And the opposite of New Jersey, if you don't sign off on either the limited tort or full tort, you're automatically given the full tort. Full tort means you have full rights to be able to bring a claim for pain and suffering without limitation. Limited tort is basically you have a limitation in regard to suing or bringing a claim for personal injury for pain and suffering unless you suffer a serious impairment of a bodily function. And that's basically based upon the severity of injury, the type of injury, the extent of treatment necessary for the injury, and how it affects your daily life and your ability to work. One other thing in the state of Pennsylvania, unlike New Jersey, is in New Jersey you automatically are entitled to uninsured motorist coverage of a minimum of $15,000. In Pennsylvania, you must elect to have uninsured motorist coverage, and you will be signing a waiver if you don't want it. In Jersey, it's mandatory to have uninsured motorist coverage, while in Jersey, it's elective. It's very important in Philadelphia County to have uninsured motorist coverage because 1 in every 4 drivers is uninsured driving on the streets of Philadelphia, and sometimes people cannot make claims if they don't have uninsured motorist coverage because somebody that causes an accident may not have insurance, and then you would seek uninsured motorist coverage through your own policy. But if you don't have it, you can't make a claim, an insurance claim, in regard to being compensated for the injuries you've suffered.
Now, Rob, We heard Steve talk about the fact that in order to recover non-economic, or I think we also refer to them as pain and suffering damages, you need to meet certain criteria if you choose the limited tort. In New Jersey, if you're subject to the limitation on lawsuit threshold, does that apply only to non-economic claims or economic as well?
No, it only applies to the non-economic claims. You always have a right to bring a claim for your economic losses, lost wages, or some certain medical expenses themselves that may not have been covered. But typically, it's the lost wage claim that is covered as a economic loss.
And we heard Steve talk about this uninsured motorist coverage, and also I heard him say underinsured motorist coverage. What's the difference between those two? Uninsured, obvious, is we know what uninsured motorist coverage is. It's for somebody that hits you and you're not insured. Steve explained that. What's this underinsured motorist coverage?
Underinsured motorist coverage is something where you have the right to purchase that, and what that provides is it provides you with coverage in the event that you were injured by another driver who had insurance but not sufficient insurance. So in other words, in New Jersey, the minimum mandatory requirement is $15,000 worth of insurance. So if you're involved in an accident with somebody who had a $15,000 policy and you have purchased for yourself underinsured motorist coverage of, as an example, $50,000, when you're involved in an accident with this other driver, if your injuries are more than $15,000 in terms of the value, you're entitled to recover from the at-fault driver his or her $15,000 policy.
And then you look to your own policy to fill the gap between what you've recovered and what your total
exactly
damages are.
the difference between the 15 and the 50.
Understood. Now, Steve, before we get away from this issue of limited tort and what you need to satisfy in Pennsylvania, I heard you talk about the criteria that's necessary in order to recover in a limited tort situation. Who determines whether or not it's had a serious impact?
It's usually the fact finder, either a judge, an arbitration panel, or a jury that will decide this issue. In the state of Pennsylvania, as I said, there's a hodgepodge type of formula. There's no exact formula or category as there is in New Jersey, where New Jersey has 6 categories. Pennsylvania looks at all different types of factors, and the most important factor from my perspective is how it has affected this person's life and the type of injury this person has. If this person has a strain and sprain and their life has not been affected and they're subject to the limited tort election, it may be difficult to recover non-economic or pain and suffering damages, when in some instance somebody else has a surgery or a herniated disc that is causing nerve damage, they're unable to work, their social and recreational activities have been significantly affected, and their ability to, their lifestyle changed basically as a result of the injuries. Those are the type of cases where non-economic damages are potentially awarded by juries, verdicts, or judges, and those are the pain and suffering categories that these fact finders look for.
Now, since there's not the 6 medical categories as there are in New Jersey, is that to say that you don't need to have a physician certification in order to pursue a claim when you're subject to the limited tort in Pennsylvania?
That is correct. You do not need an actual certification or affidavit from a physician saying that somebody suffered a permanent injury. The difference in New Jersey is that you need to suffer some sort of permanent injury if you're subject to the verbal threshold. In Pennsylvania, the statute's clear that you suffer a serious impairment of a bodily function. The law has been defined as serious does not have to always mean permanent. From a lawyer's perspective, we believe, and we look a lot on regard to these limited tort cases, that somebody should have a significant or permanent injury in order to be compensated appropriately for non-economic damages when somebody has elected the limitation to sue, also known as limited tort.
Now, Rob, with regard to medical bills, who pays for your medical bills when you're injured in a motor vehicle accident?
Although many times when clients come into our office, they don't like to hear this, New Jersey is what's called a no-fault state. And as a no-fault state, just like the words say, it means that your own insurance company is responsible for paying your medical bills regardless of who's at fault for the accident. And in New Jersey, a standard policy, although you have a right for less, A standard policy provides $250,000 worth of medical expense coverage for injuries that you may suffer in an automobile accident.
Steve, in Pennsylvania, is there that same $250,000 in available medical coverage?
There is not. It is a no-fault state, meaning no matter who's at fault, you have to seek medical benefits for your medical care through your own policy or a policy of a resident relative you live at. The minimum coverage on these medical benefits is $5,000. A majority of people in the Philadelphia area have $5,000 in medical benefits. After the $5,000 is exhausted, if exhausted by the medical treatment, you have to use your personal health insurance. If you don't have personal health insurance, you have to you present that as an economic damage, as an excess medical bill, and the person that had caused the accident is responsible for that excess medical bill above the $5,000.
Now, Rob, in New Jersey, your own insurance company is paying your medical bills. And is the insurance companies liberal in terms of the types of bills they'll pay and the amounts of bills that they'll pay that a client accrues?
No, it's an absolute nightmare in New Jersey for the unfortunate person who's been injured.
And how so?
Well, the insurance companies in New Jersey essentially are in the business of collecting premiums, and they don't do a very good job of worrying about their customers. And what I mean by that is when somebody's injured, within the first 10 days they can go to any doctor they want and the bills are required to be paid. After that, the insurance companies in some respect get to control the type of treatment by...
Do they control the doctors that you go to?
They don't. They do not control the doctors. You can go to whoever you want to go to, but if you want certain types of procedures, they require a pre-certification, meaning that the doctor has to contact the insurance company and get certain types of treatment pre-approved. We have something called care paths, which based on the type of injury you have, there's a protocol that says if you have a back injury, you get X number of chiropractic visits or physical therapy visits. And then after that, the insurance company has the right to have you examined by their doctor, who, as you can imagine, very often will find that no further treatment is necessary.
Steve, in Pennsylvania, do they have those care paths?
They do not. In fact, as I said previously,
Steve, hold that thought, and
Sure.
We'll be right back with more Law Talk. Thank you.
Law Talk is brought to you by Pond Lehocky Stern Giordano, workers' compensation and Social Security disability attorneys, delivering results with compassion. If you've been injured on the job or out of work because of illness or injury, call the attorneys at Pond Lehocky Stern Giordano at 866-INJURY-LAW. We've helped thousands of people receive their workers' compensation and Social Security disability benefits. Call today for your free handbook on workers' compensation and Social Security disability and a free consultation. You will not pay a fee unless Pond Lehocky wins your case. Pond Lehocky Stern Giordano, a proven history of success, delivering results with compassion.
Attorney Gene Laux has been representing the people he grew up with here in Philadelphia.
I've represented the children of my father's friends, the children of my father's friends.
Many of these factory and shipyard workers died of mesothelioma. It could have been avoided.
The companies place the value of profit above the value of life.
If you or a loved one has an asbestos-related disease, call the Laux Law Firm. We're here to help.
And we are back talking about motor vehicle law in New Jersey and Pennsylvania. Rob, your practice located in Trenton, what type of work do you do other than motor vehicle law?
Well, Carl, we do primarily all personal injury law that there is. I am a certified civil trial attorney by the Supreme Court. So what that means is that what our firm does is we try cases. We're courtroom attorneys. There are many attorneys out there that do personal injury by way of meeting a client and trying to resolve a case quickly. Our firm is a trial firm that handles cases with the idea towards expecting to have to roll up the sleeves and really do battle with the insurance companies to get the maximum results for our clients.
And Rob, you co-authored a book on motor vehicle law, did you not?
I did, actually, with you, Carl.
Shameless self-promotion.
We wrote a book on New Jersey automobile law in New Jersey for use by other attorneys in determining how to pursue a matter involving an automobile accident within the state of New Jersey.
I remember that. Steve, with the firm of Master Weinstein, Schatz, and Moyer in Philadelphia, but we also practice in New Jersey as well?
We do, and we have an office in Haddonfield and Philadelphia, and we go all around the counties in Philadelphia, Montgomery, Bucks, Delaware County, Chester County, and South Jersey, but predominantly our focus of practice is in Philadelphia County. We do workers' compensation also, we do personal injury, I do some commercial litigation, and I do some construction building litigation which arise from new constructions of houses and injuries that arise from houses that were recently built by builders. We try cases, we push things to the maximum as we can. We're very aggressive, and we do what we need to do to make that client happy. As you know, we are in a service business, and making the client happy and doing what's in the best interest of the client and making sure that they feel satisfied is very important to all of us at the firm, and we're all happy.
Great. Rob, we've been talking, at least the first segment, about a victim of a motor vehicle accident and what coverages they may have under their policy. How about a driver that's at fault in an accident? What coverages are available to them to insure them against the risk that they've now created for themselves?
Well, again, there's a standard policy, which is what most people have in New Jersey. And under a standard policy, you have a minimum of $15,000 of liability protection. Certainly it is, my opinion from all that I've seen over the years, that itself, even though that's the minimum mandatory, it is not sufficient. Then people really should have much higher limits than that, and should always make sure that they're purchasing underinsured and uninsured motorist coverage to protect themselves against what typically happens, which is, unfortunately, you typically wind up getting involved in an accident with somebody who doesn't have very good insurance. So it's important to worry about your own insurance as well. The other type of insurance that New Jersey has, which really isn't insurance, so to speak, is something called a basic policy. And it's just
How much liability coverage does that provide?
Zero. It's a basic policy, and basically what it provides is a card that you can show to a police officer if you've been stopped while driving or if you've been involved in an accident. But it doesn't provide you with very much coverage. It doesn't provide, we talked about no fault and getting your medical bills paid. Somebody who has a basic policy, there's two things that happen. If you have a basic policy, you're subject to the threshold, and for your insurance coverage for your own medical bills, you are only entitled to emergency room, basically emergency medical treatment coverage, or if you've been involved in a catastrophic injury, you, under certain circumstances, would be able to convert to a full $250,000 PIP, but under very limited circumstances. For the injured person who is involved in an accident with somebody like that, they have to proceed through their own insurance company under an underinsured motorist claim, which you don't automatically have with your policy unless you've purchased that.
Steve, Pennsylvania, do they have mandatory minimum coverages that the driver must purchase?
Yeah, as you see on TV, the audience may see Safe Auto, Drive for Less, minimum coverage. The minimum coverage in the state of Pennsylvania is $15,000 per person and $30,000 per occurrence. And getting back to your last question, you were talking about what do you do when you think you were at fault with an accident. I get a lot of calls from my clients, and the first thing I do is I tell them to report it to their insurance company, but I also advise them and consult them on what to do with the insurance company. Some insurance companies will have them give recorded statements immediately, and some people are shaken up right after an accident. I tell them to just take their time, tell them you'll call them back, and consult with an attorney before making any statements that are recorded, because you have to protect your rights, especially with minimal policies in regard to $15,000 per person, $30,000 per occurrence. There's currently legislation pending in the Commonwealth of Pennsylvania to increase the minimum limits to $30,000 per person and $60,000 per occurrence. And that is currently pending. That is due to increased medical costs and increases in regard to property damage. One other thing is, when you have a policy in Pennsylvania, they're looking to increase the limited coverage for property damage to $5,000 to $10,000. meaning if you cause an accident, you may be responsible for paying the property damage of the other person's car that you hit or you caused the accident with, and the minimal coverage is $5,000. There's currently legislation to increase that to $10,000 to protect consumers more in the Commonwealth of Pennsylvania.
Rob, speaking of property damage, in New Jersey, if someone's in an accident, who pays for the property damage?
You have two options in New Jersey. You have the easy option, or you have the difficult option.
Okay.
The easy option is you go through your own insurance company, and they're required to pay at 100% of the damage or value of what's been damaged, but you have a deductible. And that amount is an amount that you choose with your policy that you have to pay out at the time you're getting your car fixed, or if your car is a total loss, you're losing that amount of money. Your insurance company will then subrogate, meaning your insurance company will then fight with the other driver, the at-fault driver's insurance, to get back what they've paid to you or paid on your behalf, and they get you your deductible as well. So you may have to wait a couple months. So for somebody that's financially able to do that, it's the easiest way. Many people don't have the ability to lose $250 or a $500 deductible. In that scenario, they have no choice but to proceed against the other driver's insurance for their property damage. My feeling is that it's always best, if you can, to have an attorney help you with that part, as well as any personal injury claim you have, because it can set some sort of ground rules with the insurance company. In that context, they're allowed to argue fault. And many in New Jersey many carriers, insurance companies in New Jersey will, even when it's a rear-end collision, try to argue with a consumer that their insured was only 90% at fault and only pay part of the property damage claim.
Before we go to break, I actually want to stay on the subject of property damage and ask this question to you, Steve. And it comes from one of our viewers. It's Chuck from Fishtown. And he asks the following. He says, I have a 1995 Lexus, and I just had new stereo, tires, and timing belt put on the vehicle to the tune of over $4,000. I was involved in a motor vehicle accident last week, and the insurance company is now telling me that they're only willing to pay the Blue Book value of the vehicle, which is $5,000, and not compensate me for these upgrades to my vehicle. Is that legitimate?
That is what insurance companies try to do. What we try to advise our client is if they can take out the stereo or something out of the car, we would advise them to do that. If they can't do that, what I tell my clients is that they try to get the Blue Book value, and in regard to the accessories or the things they had, we call that personal property.
And you'll add that as an additional element of damages in the lawsuit?
That's correct, and as long as the receipts are provided to the attorney and provided to the insurance company when the case is litigated.
We'll be back with more Law Talk.
This portion of Law Talk is brought to you by Krasno and Onwudinjo, when you need a workman's compensation lawyer.
What you don't know can hurt you, especially when it comes to a work-related injury. And now, with layoffs and businesses closing, workers need to be aware of their rights. That's why workers depend on the law firm of Krasno and Onwudinjo. Founded by a workers' compensation judge, we have been protecting injured workers for 3 generations. Call us today for a free consultation or on the web at krasnolaw.com. Krasno and Onwudinjo, when you need a workers' compensation attorney.
And we are back for more discussion about motor vehicle law with Rob and Steve. Rob, I have one other question from a viewer that I wanted to pass along to you. This is from Cindy in Magnolia, New Jersey. And her question is, I'm a 46-year-old woman with a history of low back difficulties, including a prior diagnosis of a disc bulge. I was recently involved in a motor vehicle accident, and my symptoms, which had not bothered me for several years, have now kicked up again. Am I able to pursue a claim for personal injury of this aggravation of my pre-existing back injury?
The answer is possibly. And the reason why I say that is the first thing that we would look at when you come to our office is whether or not you've chosen to have the limitation on lawsuit threshold or the no limitation. If you have chosen the no threshold, then the answer is you're absolutely entitled to bring your claim, and there's no question about that. If you have the limitation on lawsuit threshold or verbal threshold, then the answer is it's going to depend on what your treating doctor ultimately tells us. If your treating doctor is able to give the opinion and certify that you've suffered an aggravation of this pre-existing condition to the point where it is now a permanent injury that meets one of the 6 categories, we can proceed that way. Or if the doctor is able to opine that this is now a new injury. So it really will depend on that.
Okay. Steve, in Pennsylvania, you said that we do not need a physician to sign a certification. What role, if any, does a physician play in Pennsylvania in pursuing a motor vehicle accident claim?
Well, the physician would basically oversee a treatment in regard to a patient, send them for diagnostic studies if needed, EMGs, which is a needle test, MRIs, CAT scans. And a doctor is essential in regard to diagnosing the injury somebody may have and whether the injury the person has is related to the motor vehicle accident. Without relating the injury to the motor vehicle accident, it's impossible to prove that the injury was caused by the accident. You need some medical testimony, medical reports, which reflect that injury was caused by the accident. In regard to the type of injury and how it affects the person's life and what's the prognosis for the person, you'd have to have a doctor opine that the injury was a serious impairment of a bodily function or a permanent injury in regard to that limited tort. So it's essential for a treating physician to be able to provide the proper opinions concerning the diagnosis and how it relates to the motor vehicle accident.
All right, and we will be back to wrap up on Law Talk.
Need a new rug? At Barton Discount Flooring Outlet, our large inventory means low prices. Our shop at home service makes it easy to save. Our financing options and next day installation makes it simple to choose Barton. Right now at Barton Discount Flooring Outlet, save on thick plush carpet by Shaw starting at $159 a square foot. Bruce solid hardwood starting at $339 a square foot. Laminate by Mohawk starting at $149 a square foot. And Maddington vinyl starting at $1 a square foot. At Barton Discount Flooring Outlet, customer service is a sure thing. Your head-to-toe flooring dealer in South Jersey.
Well, gentlemen, we've reached the end of our show. Before I let you go, though, I just want to ask you, so that there's no confusion, with regard to the verbal threshold in New Jersey and the limited tort in Pennsylvania, Rob, let me ask you first. If you have the verbal threshold, should you still pursue a claim?
Absolutely.
And Steve, what is your opinion on that?
My opinion is the same as Rob, and the answer is yes.
All right, gentlemen, thank you very much for coming in. In the coming weeks on Law Talk, we're going to be discussing a variety of topics, including product liability, matrimonial law, construction accidents, occupational exposures, and other things that affect you as the consumer. Until then, have a great week. If you have any questions, please email us at info@lawtalk.tv. Have a great week.